Daily course list, item number 1 for pronouncement of judgment.
Your phone?
Respondent.
Well, then, nobody's here. I'll just read out the opposite portion. Accordingly, these two sets of appeals are hereby disposed of in the manner as indicated herein above, with the award to be paid to the respondent claimant within 6 weeks from today, together with interest at the rate of 6 months, 6% PA from the date of filing of the claim application till realization of the same.
Like.
Check, change. Yes.
Please, Lordship. She will make mention for item 12, Lordship. Item 12, Lordship.
I think this matter is supposed to be heard.
Lordship. Lordship, doctoring counsel is indisposed, Lordship, today. So, after.
Anyway, I think next time around, no more judgment will be on prayer made by on behalf of the learned counsel, appearing for the learned senior counsel, appearing for the petitioner, who is said to be indisposed. The same not objected to by the respondent. Matters adjourned. This is the same of the petition.
Should have similar prayer for item 15 as well, Lordship.
On pre-made by petitioner, this is part of the vacation.
May please, Your Lordship, I beg to make a mention on part 2 of the hearing list, item number 14, Your Lordship. I'm yet to receive this inquiry report. So, if this matter may be taken up after winter vacation, Your Lordship.
I am also for the respondent, but I have the records with me.
You should have
my records are ready.
But shared with him.
It is his proceeding, separate proceeding, my lord.
Okay.
My proceedings I have.
Who's for the petitioner?
Lingdo.
Mr. Lingdo used to be the.
Have you sought his counsel?
I'll inform him, Your Lordship. Because I'm yet to receive that departmental inquiry. They have sent me their entire petition, not the original their departmental inquiry, Your Lordship.
On pre-made by the respondent, state respondent, this is matter of the petition.
My please, Lordship, I take the Lordship indulgence to move one matter tomorrow. It's a writ matter, writ petitions, my Lord. The reason I'm unable to make a mention of the quorum number 2 is that in 2018-19, the learned judge was representing the respondent here. With regard to creation of a village. Now this issue, my Lord, one ring village is a huge territory comprising 7-8 localities. So once, my Lord, in 2013-14, there was a claim that we became a full-fledged village. The matter reached to the executive committee. Executive committee decided that yes, there is a village. Now the matter, executive committee decided that there is no village. It's only locality. Now the matter reached to High Court, the Guwahati High Court. Then Guwahati High Court. Justice YP decided that yes, there is no village. There is no creation of new village. You're only locality. And there is a disputed question of facts. The High Court or the High Court is not right forum. Matter went for appeal also. In 2015, the Lenity Division bench of this Honorable Court upheld the decision that it is only locality. Now, December 2022, the fresh application was moved directly to the Executive Committee, District Council. And all the 7 localities are declared by the Executive Committee as new villages. Therefore, there is some sense of urgency. You will also allow me to move tomorrow.
But how, you see, how will that affect, I mean,
My
as
lord.
far as the urgency part is concerned?
Yes.
How will that affect you?
My lord, now,
That exercise, you see, that exercise may be conducted, no doubt. In due course, you will be allowed to participate or rather file your objection.
My lord, there is no scope for filing objection. This the Executive Committee has decided already. There is no more forum for us to go except my lord court. And regarding urgency, suddenly, my lord, all the 7 localities become a new village. And there is a completely breakdown of the administrations. My lord. Therefore, we want to bring lordship notice regarding this matter.
But whether locality or village,
My lord.
or villages for that matter,
Yes.
you are still governed by the,
My lord, Ilaga Act.
By the Act.
Lordship is very correct. 1991 Ilaga Act clearly says that creation of a village is vested with the Kairim Simship, the chief, with the majority view of the parent village. After he create that one, he will obtain the approval from the district council, and the village, the locality will become a village. Now, Kairim Simship, my lord, admitted that there is no such a creation of a village, and he is the grading authorities. So grading authorities say that there is no creation, and the executive committee say that it is created.
But we'll hear the matter tomorrow.
But highly appreciated.
My lord, I also crave my lord's indulgence. A matter to be listed on the vacation bench, 28 is my lord's vacation bench, my lord. And why I'm mentioning here is, my lord, because number one, the filing is closed. We have been informed that new filings are not taken. And second, the urgency here is, my lord, there was an advertisement for the post of 2 posts of state organizer in the Meghalaya Bharat Scouts and Guides. Now I am one of the candidate, my lord, and I was appointed as an assistant state organizer, and I have all the requisite qualifications. However, my lord, my candidature was rejected, saying that I don't fulfill the advertisement requisite qualification, which is not true, my lord. Whereas another candidate, my lord, who was not even assistant state organizer, her candidature was accepted. And when I file an RTI, this candidate has submitted an experience certificate, my lord, which the on the inquiry, the secretary herself says that no, I have not issued this experience certificate, and certain procedure and this and that happened. But suddenly, my lord, now the interview was called in a very harsh manner, in a very rushed manner. Her candidature, she was selected. So anytime, my lord, they might issue an appointment order to her. Therefore, my lord, there's some very arbitrary and illegal things have happened against me, my lord. Therefore, I'm challenging the candidature, my lord. So vacation bench, my lord, because I'm not asking for tomorrow. After Christmas, 28 is a vacation bench.
Take a call then.
My lord, my lord. Obligation.
Lordship, I beg to mention item 11, my lord. So we are required to file a reply in the miss case. I'm praying for some time, my lord.
You are paying for?
The petitioner.
This matter is connected to item number 3 on my lord's list. Let item 3 come up, my lord.
Oh, that.
Lokayukta matter. So they have challenged my locus. I have filed my reply against that challenge. They sought time to file a rejoinder against that.
In 3 also.
Your Honor?
Lordship, we had sought
No, in 3 also, yes, somebody is to file a rejoinder.
the state lordship,
The
the state lordship, and we have not been able to file lordship. So even in that matter, though it's a division hearing, we'll seek time.
We'll go look after. We'll see that everyone gets a reprieve, whatever the case may be. On matter on made by petitioners by the parties, this is matter to vacation. So both 3 and 11 then.
Very,
My lord,
very.
much obliged, lordship.
Much obliged.
Lord, I beg to make mention of item 10. Lord. Though the affidavit is ready, my lord, I could not file it. If the matter is taken up after vacation, my lord, in the meantime, I'll file it.
It's a long pending matter, Mr.
Yes, my lord. My apologies.
If you go on year after year like this, then when will the matter
No,
end?
we'll next date we'll finish it, my lord. If possible, I'll try to file it by tomorrow, or I'll try my best.
On pre-made by the landed G, seeking more time to. You have to file what? What are you supposed to file?
My lord, regarding the who's the authority, my lord?
Applicability of the whether any tribunal has been constituted as per the RT rules or not. That is the issue.
You're supposed to file in form of an affidavit,
Yes, my lord.
seeking some time to file the additional affidavit as additional affidavit
Additional affidavit.
as prayed for. That is on the petitioner not objecting to the same matters adjourned. This is same notification.
Obliged, my lord.
I beg to mention item number 16, Lordship. I'm from respondent number 6. Let the matter come after winter vacation. Item 16. I'm appearing on behalf of the petitioner, Your Lordship. No objection, Your Lordship.
You're
Respondent number 6, Your Honor.
on 6. On pre-made by respondent number 6, not objected to by petitioner. This is matter after vacation.
Much obliged, Lordship. Item number 2.
May it please your lordship.
Supposed to file the written synopsis of the argument.
So what is required here?
Lordship's order. Because the hearing is complete, my lord.
Hearing is concluded.
Lordship instructed us to file our written.
Parties have filed their respective written argument. Judgment reserved.
Published.
Item number 5.
Oh, sorry. Respondent number 5, private respondent. Oh, I'm appearing. May it please your lordship. Your lordship, we have submitted the name of the legal heir to the petitioner, your lordship, for them to take necessary steps for substitution.
Who's appearing? Petitioner?
Mr. A. Pakinten, Ivan Pakinten, lordship. Who's not here today, it seems.
None has appeared on behalf of the petitioner. Our Ms. Zadi Leonard, counsel appearing for the respondent number 5, has submitted that the names of the legal heirs and legal representative of the deceased respondent 5 has been filed. Have you filed?
Not by way of an affidavit, Your Lordship. We've just supplied the name to the petitioner.
Have been supplied to the petitioner. Is that acceptable?
Your Lordship, because
Can they take steps on the basis of your, in the information given to them?
Because, Your Lordship, as per my instruction, Your Lordship, we were just supposed to give them the name of the legal heir, Your Lordship. If it's required to be filed, Your Lordship.
Enlighten this court as to what is required. I'm very rusty with the CPC, so tell me.
Your Lordship, if I may be allowed
No,
to
tell
file
me
it by
what are
way of
the
an affidavit.
what is the provision required?
Your Lordship, Order 22 rule. I don't have the CPC with me also, Your Lordship. Order 22 rule 3, Your Lordship.
Yes, read out what this is.
Your Lordship. Your Lordship, I apologize. I'm just looking from the phone, Your Lordship, because I don't have the book with me.
This talks about the death of a plaintiff or plaintiffs. That's 4. This is the procedure whenever any of the party dies, plaintiff or defendant. I think we are clear on that. Only to the extent of whether the names of the legal or the legal heirs is to be, who are they required to make an inquiry on their own, or representative of the deceased is to file the name? Yes, Mr. Khan, you want to assist the court?
Well,
Tell me.
in case of the death of the petitioner who has filed the petition, in case of the death, then what happens? The death certificate is furnished accordingly. It's brought on record, and then it's accordingly substituted.
No, but here is a case where one of the defendants, or rather respondent, has died.
Yes, yes.
And the petitioner
Then in that
is to take steps.
yes, my lord. Then in that case, the defendant, the respondent defendant, they have to furnish the death certificate. And once the death certificate is furnished, then what happens? That the petition is accordingly is to be amended by substituting.
Yes.
It's a duty of the petition.
Filing of death certificate will only prove the fact that somebody has died.
Yes, yes, my lord.
But as far as the legal is concerned,
Yes.
just I'm putting a hypothetical, question.
Yes.
The plaintiff or the petitioner may not know who are the legal heirs.
Correct. So it is a duty of the
It could be
yes,
sons, daughters,
yes.
brothers.
In case
sister,
of the
whatever.
death of the respondent,
So it is incumbent upon the representative or the relatives of the or legal heir, for that matter, of
Yes,
the
yes.
deceased to furnish the name.
furnish the death certificate.
How is that to be done?
My lord,
Whether it's to be done by way of an affidavit or just by word of mouth or just
my lord,
that's-
that basically
I wanted to
since
see from
since my lord, since this High Court is a court of record, so what happens that that certificate generally it can be given by way of affidavit.
that certificate. Okay, we are clear on that.
Yes, yes.
We are only now on the issue of legal heirs.
Legal heir. So
Because
accordingly,
the plaintiff or the petitioner for that matter
yes,
is required to substitute them by way of an application.
yes, by way of an
Then
application.
how will he know who are the legal heirs if that information is not given to him?
Correct, correct.
How
So
it is
that
to be done?
it
That's
is
what
it becomes incumbent on the part of the defendant to produce the death certificate and bring it before the court by way of record. And then what happens in place of the person who was alive, it has to be substituted on record. And at times, sometimes it is written on the body of the petition also, substituted by so and so, need not necessarily be amended. Otherwise, generally amended petition is to be filed by way of once the legal heir is substituted. But at times the court allows that on the body of the plaintiff substituted by so and so, so that the case cannot proceed against a dead person. It has to proceed.
exactly. Who is to do that?
If the defendant, in
the
case
defendant
of
should do that.
yes, in case of the death of the defendant, my lord, the duty of the defendant, the respondent, it becomes incumbent on their part to produce death certificate, and accordingly, on the body of when the court finds, when the court is satisfied, yes, so and so is the legal heir, then it has to be brought on record by mentioning in the body of the the petition or amended. It has to be.
Exactly. So that exercise has to be carried out by the defendant. Or
No, no, my lord. This exercise, in fact, it has to be carried out by the petitioner.
no, yeah, exactly.
The duty of the defendant is to furnish the death certificate.
furnish that is.
Yes, but so far, if there is a death of the petitioner, then he has to
No,
substitute.
that of course.
He has to do.
He has to be.
But when it's a death of the defendant, then the defendant, it becomes incumbent on the part of the defendant to produce only the death certificate. Once the death certificate is produced, that X and Y or whoever is the legal heir of the deceased, and that is brought on record, and then at times can be mentioned in the body of the petition, or
You see that is why we are going round and round. But the fact is, it is incumbent upon the defendant.
yes,
You know, after providing the death certificate,
yes,
you still have to indicate therein, or in a in a form of an application.
yes, in the
Or
form.
even you like you said, informally say
Informally.
that the deceased is substituted by so.
So and so, maybe substitute.
So that
being the legal
that
heir.
will have to be on the record of the,
Correct.
so that the
Your Lordship,
petitioner,
I'll file it by way
the
of an
petitioner can
affidavit.
take steps.
Yes.
Because if you say just by word of mouth, it may not.
Correct. And a copy is
It may
furnished and
dispute
accordingly.
Yes, it's better to be on record, Lordship.
Might as well.
That's what.
Your Lordship, if I may be allowed some time to file it by way of an affidavit.
So you do that. Kunun to? Yeah, I know that has submitted that she may be allowed to file an appropriate petition to bring on record the legal heirs and legal representative of the deceased respondent number 5, or to enable the petitioner to take necessary steps for substitution if so advice. On primate, this seems allowed. This is matter of vacation.
Obliged, Your Lordship. Your Lordship, items 5 to 9 are connected.
Same order.
Item number 13.
None appears for the parties. This is matter of vacation.
Yes, sir. 33 days of delay.
Heard, Mr. Counsel for the applicant. For the petitioner, no? The counsel for the petitioner was submitted that the related appeal has been filed before this court against the judgment and order judgment dated 8/9/2023 and sentence dated 12/9/2023 in special POCSO case number 37 of 2020. However, a delay of 33 days has occurred while preferring this appeal, for which condonation of the same is sought for in this petition. Mr. You appearing for respondent? Mr. Argun Leonard G appearing for the state respondent has no objection to the prayer made. On good grounds being shown, delay is condoned, petition is allowed. So, registry is directed to diarize the appeal and allot specific number which will be heard in due course. In the meantime, the record of the trial court is hereby called for, and the appellant is directed to prepare a paper book within 6 weeks from today, 8 weeks from today, the matter to be listed thereafter.
Item number 3.
Supplement.
In the PS case,
my lord, yes, my lord, there's a delay. We have filed an appeal under section 21 of the NI Act, my lord, National Investigation Agencies Act, my lord. So any order that has been passed, that either rejecting of the bail or allowing the bail, it comes by way of it provides, section 21 provides by way of an appeal before the division bench of the High Court, my lord. So earlier we had withdrawn, we had filed under CRPC the bail, but then we have withdrawn, and now we have filed with the proper. But in doing so, my lord, we are late by 113 days, my lord, 113 days, my lord. And I have explained in paragraph 4 of this miscellaneous application 108, my lord. And my lord, this is little explanations, my lord,
yes.
My lord, section 21 of the NI Act, my lord, prescribes limitation period of 30 days and prescribes the outer limit also, my lord. If Lordship kindly has section 21 of the NI Act. Subsection 5.
Yes.
Every appeal under this section shall be preferred within a period of 30 days from the date of the judgment, sentence, or order appealed from, provided that the High Court may entertain appeal after the expiry of the said period of 30 days, if it is satisfied that the appellant had sufficient cause for not preferring the appeal within a period of 30 days, provided further that no appeal shall be entertained after the expiry of period of 90 days, my lord. Here they are coming after 113 days, my lord.
Section 21(5), my lord, it's only a directory and it's not a mandatory, my lord, and that has been interpreted by the Delhi High Court, my lord, in a judgment. We have just applied in a judgment reported in 2019 SEC Online Delhi 9158, my lord. And in this, my lord, for the benefit of my lord, I'll just read this small set. Even here, my lord, they came after the statutory period, my lord. And then it says that we are inclined to hold.
Mr. Yogin, if you are relying on some decision,
my lord,
at least courtesy demands that you give a copy to us.
Oh, okay. What do you mean, Mark? My lord, I'll just read. I'll supply, my lord. I'll just read the operating part, my lord. What they have held. We are inclined to hold that the prescription of limitation in section 21(5) of the NIA Act is directory and not mandatory, and that the High Court is empowered to entertain and consider application under section 5 of the Limitation Act seeking condonation of delay in filing an appeal. The said application is maintainable, my lord. Just supply, my lord, this judgment, my lord. I'll give a
Look at the proviso. It says shall be.
Shall.
No appeal shall be entertained. The last line.
My lord, in this, my lord, and there is another interpretation, my lord, which has been given, my lord. And in the case of we'll give this also, my lord. In the case of Farhan Sheikh, my lord, it has been explained the shall used in the second proviso to section 21F shall be read as may be. I will supply this also, my lord.
It shall be read.
My lord, this is what the court have, my lord,
Now, if shall is to
interpreted.
be interpreted that way, that was Supreme Court judgment.
My lord, this is
No, if shall.
It's a Delhi judgment, my lord. It's a Delhi High Court judgment, my lord.
Then it will have only a persuasive, value. As far
Persuasive value, my lord.
My lord, if lordship permits me, I'll file a small objection, my lord. The matter can be taken up, and I'll place my own judgments also.
My lord. In the meantime, I'll place my judgments, my lord. Obliged.
Heard Mr. Piobin, learned counsel for the applicant. Dr. N. Muzika, learned DSGI, has accepted notice on behalf of the has appeared on behalf of the respondent 1, 2, and 3 respectively, and has made a prayer that a response may be allowed to be filed against this petition. On prayer made, the same is allowed that the said response be filed with advance copy to the petitioner, to the applicant, petitioner. I petitioner what? This is matter of publication.
Obliged.
Item number 4.
Take up this matter. We'll take up this matter.
File a report.
Oh, this is in regard to whether the scheme would be applicable from the
RCW, my lord.
date of.
Not as far as the OM, of course, she is not entitled, my lord, because it says that service has to be 10 years. So she will complete 10 years because she was taken in 2021. She will complete 10 years only in 31, my lord. Nevertheless, my lord, pursuant to the directions of this honorable court, the department has considered from the date of, my lord, issuance of the said order, my lord.
So they will consider from 2003. That is their prayer, isn't
No,
it?
no, from the date of issuance of this order. My lord, kindly, my lord, may I take my lord's attention to the order of this honorable court dated 12/10/2023, my lord.
Yes.
If I am allowed to read, my lord.
Please.
The state indicates that by a letter of September 20, 2023, the appellant here has been accorded RC regular casual worker status. However, the appellant claims that the appellant was entitled to regularization. Further, without prejudice to the appellant's rights in the appeal, the appellant claims that at the very least, the RCW status should be granted to the appellant with effect from the year 2003. The appellant submits that the recent letter of September 2023 does not throw any light on such aspect. The state should clarify whether the RCW status of the appellant will date back to 2003. In such event, if the state indicates as such, the appellant's grievance may have been addressed. Let the matter appear so and fortnight, hence so and so, my lord. Now this fact is, my lord, clarified. So because the state was asked to clarify it, my lord, the RCW status will take effect from which date? My lord, the department has clarified, my lord, it will take effect from the date of issuance of the letter, my lord. That is September 20, 2023. This is our stand.
Well, please, your lordships. Yes, your lordship. Your lordships, now, if we peruse the materials available on records, your lordships will see that she was working as a casual worker since the year 1993. Now, your lordship, if we go as per the RCW scheme, your lordship, now it says after 10 years of working continuously for a period of 10 years as a regular casual worker, she should have been conferred RCW status. That's why, your lordship, I'm pressing that she should have been conferred RCW status since 2003. If we go by the rules, your lordship.
But that is not a fact.
Your lordship.
That is not a fact. We have also submitted in our addition.
What we have to determine is your status.
Yes, your lordship.
As on, or rather as in 1993.
Yes, your lordship.
If you have been conferred with the
casual worker.
Casual worker. If casual workers are entitled to the scheme.
Yes, your lordship. After 10 years.
She is not, my lord. 10 years service period.
Then what is?
No, my lord.
Where is the dispute?
My lord will kindly see if I may draw my lord's attention.
Because if I vaguely recall, from the last time around, what is said is that she was a casual worker.
No, she was not a casual.
Or a cleaner for that matter.
Yes,
she's a part-time cleaner. There's a lot of difference, my lord. She's a part-time cleaner. She's not a casual worker.
Now, your lordships, if you peruse the records.
Where is your initial order of appointment?
Yes, your lordship, I'll take you.
Lordship, if I may take your Lordships to page 99.
Yes.
Your Lordship, it's very clear that she was appointed as a cleaner on casual basis.
My lord, merely because the word casual basis is required, sorry, my lord, basis is reflected there doesn't mean that she is a casual worker. What is more important is she is appointed as a cleaner. Made use of that term, that has been clarified also, my lord, even if in our affidavits and additional affidavits in the
No,
first
it
round.
may have been clarified. See, but was this clarification, conveyed to her?
Yes, my lord. She's a cleaner.
Was it conveyed to her
Very
that
term
your
cleaner,
that
merely
your
because on casual basis?
see, was it conveyed to her that your status
Yes.
in employment is on
Yes, she used
no,
to
on
come in
casual
the
basis,
morning
but
hours.
not.
My lord, her service is from 8 to 10. She used to come in the morning hours, clean and go.
Now, your Lordships, with regards to the timing also, your Lordships, if I may take your Lordship to page 31, your Lordship, you'll see the timing. She works from 8 a.m. to 2 p.m., your Lordships.
That is also incorrect.
What cleaner and casual has to do? Cannot be a cleaner with casual employee?
Yes.
No, my lord, there are several stages. Cleaner is a temporary, only as a temporary basis.
So casual is what?
My lord, in the...
These are the distinction, please. You are saying that you are trying to draw a distinction between cleaner and casual.
My lord, there are several categories, my lord. You have the unskilled, so my lord, then you have the semi-skilled, then you have skilled. So my lord, these are the different categories.
So who is casual and who is not casual?
My lord, as far as the petitioner is concerned, my lord, her appointment is only as a part-time cleaner. My lord.
What is the part-time cleaner?
Though the
Doesn't say
service,
part-time cleaner.
my lord,
Monthly salary per month. 1,000 per month.
Yes, 1,000 per
Monthly
month.
pay.
Yes, on the monthly basis, no doubt.
Where is the
my lord.
part-time? It's full time. You are offering per month salary.
Per month salary, my lord. But
on casual basis, that is good enough to show she was a casual worker.
But
whether she's a cleaner or she's a chowkidar or is a peon doesn't matter.
But my lord, in our respectful submission, my lord, she is to be treated as a part-time. That we have clarified, my lord. My lord,
that is your defense in the case. Whether on what basis she should be treated as a part-time. Your statement will not know that she comes in the morning, she cleans for an hour, she goes back.
My lord, will kindly refer to, my lord, page 84 of the writ appeal. This is where, my lord, this factor had also,
yes, that is
this question was also raised by the Honorable Single Bench, my lord.
Yes.
So this part was clarified, my lord. If I am allowed to read, my lord.
Yes, you can read it, but
with reference to the above, I have the honor to furnish the following facts. That Srimati Dil Kumari Chetri is neither a work charge nor ad hoc employee of this department. Number 2, my lord, she has been working as a part-time cleaner since April 1993. Her duty is only in the morning before office hour, that is from 8 am to 10 am, and she left office after duty. Her salary has therefore been fixed initially at the rate of 1,000 per month, for which it was raised to rupees 5,000 per month eventually. Number 5, my lord, it may be stated that the state has already been that she has already been brought to casual worker as cleaner on November 21, my lord. November 21, and her salary has been paid with the latest minimum wages of Labour Department. So this is what the department says.
This is your statement on what basis you are saying. It is a communication to a government advocate after institution of the case. Now, on what basis you are saying it? Whatever you have said this, there must be a basis.
Yes,
Your
definitely.
appointment letter says otherwise.
There must be a relevant, official notification, or there must be.
There will be, it will be there, my lord.
Where it is this, this person is there, and more importantly, she has to be informed of her status.
My lord, if that is so, my lord, I'll get all whatever necessary documents are there. I'll get it from the department.
No, but then what document you have annexed with your affidavit of opposition? Show us any document on the basis of which you can say. This statement would not do. This is an instruction given. Instruction has to be a certain basis.
My lord, even the salary which is paid, my lord, it was totally from a different account, my lord. Even the disbursement of the salary, because casual worker, my lord, the salary, they are different, certain different sections, my lord. From this division, this salary will go. For casual worker, it will be
salary
different.
of casual cleaner at that point of time, 1993.
Payment sheet of the month of 19th. We have included a payment sheet, my lord. This is at page 60.
Page?
Page 60, my lord. 60 of the writ appeal. And 52, there is an averment, my lord. Page 52, which is our first affidavit in opposition. So if I am allowed to read para 5, my lord.
Page 62.
First I'll refer to page 52, my lord.
52.
Yes. That with regard, my lord has found.
Yes, para 5, yes, please.
Yes, that with regard to the averments made at para 2 and 3 of the writ petition, the answering deponent states that as per office record, the petitioner was engaged as part-time cleaner and drew her first salary in the month of April 1993. It is pertinent to mention herein that in view of the fact that Srimati A. Kharmujai was on leave, the petitioner was allowed to officiate. So this is regarding some officiating appointment, my lord, against the leave vacancy of the above incumbent on a number of occasions, and such officiating appointment was purely temporary. Now at page 60 is the payments slip, madam.
Where is records to show that she's been appointed on part-time? You see it as per the records. Where is the record?
My lord, here, of course, when the affidavit was filed, here they have included the payment slip, my lord, which
Payment
is at page
slip is
60.
not showing anything. It's neither here nor there. Come to payment
My
slip.
lord, if my lord kindly comes to page 61, my lord.
Yes. What does it show for a part-time?
With reference to the subject and letter number quoted above, I have the honor to clarify that Srimati Dil Kumari Chetri is a casual cleaner since 19. This is what we have been stating.
Casual, that is what?
In which fixed amount of rupees 5,000 per month was paid to her from this wages, my lord, non-plan. My lord will kindly see. From her 2059 wages, plan / non-plan.
You have to see. You have to clarify this point also.
My lord, what had happened, my lord, on the last occasion? This will require some hearing, my lord. On the last occasion, my lord, what had fallen from this honorable court was that, my lord, whether that letter which is issued, the regularization will take it. Sorry, my lord, the RCW status will take effect from which date? So we have received a report from the department, my lord, clarification which says that it can be only.
But we are not satisfied with the report. As my learned brother has pointed out, there are so many,
So, my lord, if that is so, I'll get whatever record is there, my lord. I'll try to get it from the department.
And you have to confine only to whatever has been stated in your affidavit.
Yes, my lord, because we have clarified in our even before the single bench, my lord, honorable single bench, we have clarified that fact that she is a part-time cleaner. But, my lord, whatever record is necessary, I'll obtain from the department.
You have to distinguish between part-time cleaner and casual cleaner, or whatever you call it.
My lord, I'll also.
Lordships, if I may take your lordships to page 61, your lordships, just for a few minutes, your lordship. Now here also, your lordship, this is 2014. Here also they're saying she's a casual cleaner.
No, that we have.
No, we'll get it because as far as, my lord,
Where is your report?
My lord, the report that which I filed. My lord, if I am at least allowed to read the report. I've given
If anything is said here about, clarification or as far as the status is
my lord, a
concerned,
little detail is given if I'm allowed to go through.
yes.
Srimati Dil Kumari Chetri was appointed as a casual part-time cleaner. So what they are mentioning, my lord, that part-time is more important.
But this
Under
is
the NH.
see, this will belie the appointment order that you have, that is there on record.
My lord, the appointment order also says the same thing.
It is casual. Doesn't
No, my
say
lord.
part-time.
My lord, if I take my lord again to the appointment order, is it?
Page 99.
Yes, my lord. Appointed as a cleaner.
Yes, casual. Yes,
On
appointed
casual
as
basis.
cleaner on casual. Doesn't say part-time.
So, my lord, but this is what so far the report says, my lord. If I'm just allowed to read.
The report is wrong.
My lord, if my lord kindly allows me to go through, my lord.
Please.
Srimati Dil Kumari Chetri is appointed as a casual, part-time. Casual we have mentioned here. Part-time cleaner under the NH Shillong
Part-time you have
bypass.
added here. Part-time is nowhere there, only here it is. You have added this word here in this report. On what basis? Just you want to say it, that is why you have included.
Lord, my respectful submission is that is not the case.
See, this, if you want to show that you want to claim that she was a part-time cleaner, then you have to show us a document dated back to a date of appointment where she was shown to be part-time appointee. Show us. This is only report will not do without any supporting document.
So, my lord, I'll
It's
get
official
supporting.
document.
I'll get supporting documents.
The chief engineer who has signed it, was he a chief engineer in 1993?
No, my lord, they must have retired by now, my lord.
Can he speak from his own knowledge without
That must-
supporting, without giving any supporting?
They'll fall back on office record itself. Whatever is there in the office record.
Heard Mr. K.P. Bhattacharya, Lord G, who has submitted that the report has been filed in compliance with this court's order dated 5/12/2023. However, on perusal of the record of the said report, it is found that the same is not complete as far as the subject matter is concerned, and the Lord G has submitted that he may be allowed to furnish an additional report with all relevant information. All relevant information and documents which are relevant more documents. This you can if you want to file a rejoinder, then you can do it when the complete report comes. This we are not satisfied with this report.
This is a report, my lord. Whether
So they may go through.
they may go through.
As you have said, you see,
This report is neither an
the very first sentence you have pointed out is the word part-time. They are allowed to refute that. Anyway, as prayed for by the parties, this is matter of application.
Second call from supplementary cost list, item number 1.
Lordship, I apologize for not being able to present at the time when the matter was called, Lordship. I went to attend the
Where
call
were you?
officer.
Having tea.
Here, Lordship, my Lordship is aware of about the education scam, Lordship, that happened in 2008, Lordship. Then, Lordship, the selection process was scrapped by the Honorable Division Bench of this Honorable High Court, Lordship. While setting aside the selection process, Lordship, some directions were given, Lordship.
Mr. Sheikh, before you go on, we have just briefly perused through the petition. From what we could understand, this is a continuation of the earlier proceedings.
Yes, Lordship.
Tainted.
Yes, Lordship.
Untainted teachers. And all.
Yes, Lordship.
So, in that respect, I think this court would be disabled to take up this matter. My brother here will not be able to take up this matter.
I don't think, my lord.
Shulai knows it probably at
Yes,
that point of
lordship.
time he was on.
Lordship, because that has got no bearing, lordship, because I am not seeking any extra, because I am just seeking the benefits of that judgment that division bench has already
It
given.
not be proper on my part because I was there once upon a time.
Counsel.
And this entire CBI thing and all.
Yes, lordship.
Was so we are not be proper.
Now the difficulty is that, lordship, that appeal arose from the order, the lauded that the acting chief justice. He says thank you. So I will be.
Wait for your luck. By the meantime, if you get
my lord,
that
that
chief justice, you can make
interview is in process, lordship, because so far as the Garo medium is concerned, lordship, that it started into 13th of this month, lordship, and so far as the Assamese medium is concerned, it will start from 5th and continue till 9th of January, lordship.
No, by that time, who knows? Anything might happen, or new chief justice may join. There's nothing we can do.
My lordship have expressed
this matter before any other bench without J.
Even lordship, then because my that acting chief justice also cannot take up this matter, lordship.
So it will come, like I said, in due course. Once the new chief justice joins, let's hope he joins tomorrow. Thank you.
Obliged.